first. The court finds, correctly as it did, the decision of the Minister of Urban and Rural Development to selectively implement Section 97 of the Electoral Act as unconstitutional and inconsistent with the law. It of course also goes and says that there is a question about separation of powers and that the parliamentary law made and assented by the president that became law could not be unilaterally altered by a member of the executive without the parliament again making such changes. This is the long and short of it. But what is interesting of the same court is that it goes and gives an order of invalidity because it recognizes that the 2014 elections were also done using the same system of EVMs without a verifiable paper trail, and recognizes therefore that its finding of that provision of the government notice basically setting aside the full provision of Section 97 is unconstitutional. Making that finding creates, of course, in the mind of the court a difficulty that the actions taken by the government from 2014 up until 21st March 2020 could also be equally invalid. It's an important decision, it's an important consequence. But they sort of go back quickly to back up that order and says, no, those matters are not affected. In other words, the work of the government elected from 2014 is not invalid. It makes that order. It then says that they make a further order prospectively that those elected in the 2019 elections have also been generated through the very same process of an EVM without a verifiable paper trail. So it recognizes two elections are done without what the law would fully require, the verifiable paper trail. And it says that please make sure that you go and change this, and gives a prospective order of invalidity. In other words, if you don't change this provision that you have made as minister, what will eventually be done by the government would be invalid from the 20th of March or from the 21st of March 2020. That is what it says. Now, one must of course concede and congratulate the applicants for having succeeded in the Supreme Court overruling the Maletsky judgment. The Maletsky judgment was brought to court on an urgent basis before the 2014 elections, as you know. In that instance, for some reason, the High Court ruled that the use of EVMs without verifiable paper trail was legal and that the ECN could proceed in that accordance. This court yesterday overruled the Maletsky decision and says it was unconstitutional that EVMs could be used without verifiable paper trail. Now here comes the question of moral courage. And here comes our suggestion, as we've always made, which is evidence now, that the Supreme Court, as representative of the judiciary, and in fact the entire judiciary, is but a captured system of the deep state that represents Swapo and the elite setup, and was never going to order the setting aside of the presidential elections. We said it. That is why when we had our discussions around how the elections were rigged, we said that we are not going to the same Swapo cause because they will never, in the fundamental issues of setting aside elections, they will never disappoint the masters who they serve. The Supreme Court and the Judiciary, with a few exceptions, are supremely loyal to those that feed them, that pay their water bills, that hire their wives also as judges of the courts, that may also end up promoting their wives as judges into the Supreme Court at some stage, with few exceptions. So let us get back to some of the factual issues. Our view first is that the Supreme Court erred in fact and in law. What are the facts that we are complaining about here and stating? The Supreme Court says that the applicants did not in time raise the issue of the irregularities as they have done in this case. The Supreme Court further says that the applicants were basically relaxing and never took up the issue of EVMs without VVPAT to be used with the ECN. And that the applicants sort of waited until the 24th of October to start to complain about the matter. Nothing could be further from the truth. Even when the Landless People's Movement was registered in February, we, together with all other political parties, still in February 2019, began to take up the issue of EVMs that are being used without VVPAT consistently and conscientiously. The meetings were so hot, disorderly, and terrible that they would often end up in a disarray with people walking out. Because at all of the meetings that we attended as political parties, the ECN was very clear that come hell or high water, they will use EVMs without a VVPAT. They made it very clear. It appears that the court says that the ECN was going to consult stakeholders to see how VVPAT will be used and so on. ECN does not consult stakeholders. Those of us that have attended stakeholder meetings know. Ivan Scraver is here, Joy is here, Paul is here, other colleagues are here. ECN informs stakeholders of what ECN wants to do, and that stakeholder meeting was turned into the dictatorship of the ECN on rules, processes, procedures, and legalities as to how the elections should be run. We recall that the meetings were so intense that the ECN eventually gave a report to all political parties at one of those meetings, sometime in June, July, that said something to this effect, and I'm paraphrasing, that they, having consulted the Indian manufacturers that would produce the VVPAT, found first that the Indians are saying that they are occupied with the Indian elections and they just cannot take an order to produce the VVPAT. First. Second, that in the case that VVPATs would be used, they said that as it relates to India, the VVPAT creates a variation of 5% of the total election results. In other words, there is a 5% of the total votes in India that becomes problematic to either reconcile, because the variable of that 5% means that there are difficulties that arise in the eventual counting of the votes. They collated that figure and found ECN, without anyone else objectively being permitted to look at the veracity of their claims that they are canvassing, and to, again, with an independent eye, agree whether it is truthful what ECN is saying. We were presented with the following: that the 5% variation of the VVPAT translated into Namibia's perspective means that we will have a 25% variation of the results. And that the 25% variation of the result would affect about 250 to 300 polling stations. And that variation would be a material consequence on the outcome of the elections. And therefore the ECN was strongly against the use of VVPAT from the word go. So what am I saying? I'm saying two things. First, when they decided to use the VVPAT technology, the ECN and all other stakeholders before the formation of LPM never did a due diligence to understand if it is true what ECN is saying about the variation that the VVPATs cause. And only ex post facto recognized that there is a variation within the VVPAT that could materially affect the outcome of elections. And that is why ECN has been refusing, in our assessment, to actually use VVPATs. When ECN pretends to say that they want to use VVPATs, they want to comply with the law, they are not honest, because they have said that introducing the VVPAT would create problems in our electoral system. And they should be able to come out and clearly explain to the people of this country that given that variation that they spoke about themselves to us as stakeholders, that we should perhaps move away from EVMs themselves and bringing another technology. You don't hear the ECN saying that there is a problem with the VVPAT, that it has a material consequence negativing the outcome of elections. They don't say it. Beyond that, it is very interesting that the court, a quote,